Hello, hello, hello. David Brannen here. Welcome to all of you that have showed up bright and early here again for our daily Ask a Lawyer Live. Today we're going to be covering a topic: what happens if you're mistreated by your employer while you're on sick leave? More to the point, I guess. What happens if there's workplace discrimination against you while you are on sick leave? Usually that comes in the form of you losing your job or them taking away your job while you're off on a sick leave. So you could be, maybe it's your job was replaced, maybe they're just ignoring you, or they're denying workplace accommodations, and you're kind of left wondering, is it legal? What can I do? That's what we're going to look at today. So let's see our little slide presentation here. So this may apply to you. It may apply to someone you know, but at least now you'll have a little more information. You can give friends advice, let them know if things look like it's above board or not, and when they might want to go get legal advice. So discrimination, first of all, the thing to learn about discrimination, it doesn't always have to be obvious. So it can be subtle, hidden behind vague explanations. Here's some red flags to look for if you're off on a sick leave and you're worried that the employer may be plotting something against you. Number one, being replaced. Either you're notified that you are being permanently replaced while you're still recovering. And this can happen where you just, maybe they'll tell you, but maybe you've heard from other people that they've permanently replaced your job. Now, this is not quite the same thing as if they're just getting someone temporarily to fill in for your job while you're gone. But if you get the sense that you're being permanently replaced, then that can be a sign of workplace discrimination based on your disability. Okay. The second thing we often see is denials of accommodation. So you're off on sick leave, you're requesting a gradual return to work backed by your doctor, but the employer shuts it down or refuses to engage. This can actually happen sometimes. The employer may have different excuses. Maybe they tell you your job's no longer available. Those are all signs that you should contact a lawyer because you have a workplace discrimination case or possible case against your employer. Another common thing that can happen when you're on sick leave is just the employer will ghost you. They just won't return your calls. They aren't responding to your requests, and you send updates, but you're not getting any response. This is often can happen when The employer is probably thinking about how they're going to terminate you. They're not sure what to say. They're still having internal meetings to figure out what to do. That's often what's going on in those situations. So that is a time possibly to seek out legal advice on what you should do. The other one is sometimes you'll just get straight up pressure to resign. They'll say, like, some employers are quite bold. They'll just say, look, this job isn't for you. We've moved on. We don't feel you're a good fit. Any of this kind of thing can amount to where they're trying to get you to resign. That can actually be a dismissal in and of itself, even though they haven't formally fired you. They're trying to get you to resign so they don't have to pay any severance pay, basically. So if you feel like that's something that's going on, don't quit. Get legal advice and figure out what to do and how to best navigate that type of situation. So what are your legal rights? Even though you're off work, you still have legal rights, and the employer is not unable to discriminate against you even though you're off work. Everyone has the right to be free from discrimination based on protected grounds. Now, there are unprotected grounds of discrimination that people can discriminate against, but if it's one of the protected grounds of discrimination under the various human rights acts that affect the provinces, and also if you work in a federally regulated sector, it would be the Canadian Human Rights Act. So common ones that we work with would be disability discrimination, age discrimination. Sorry, I got an itchy nose here. Age discrimination, family status discrimination. And those would be very common ones that we deal with, because at our firm, we only deal with workplace discrimination issues, not discrimination in the broader sense. So it's things that regularly happen in the workplace. Those are very common, very common. Now, you also have a right to reasonable accommodation, short of undue hardship. This means that the employer has to engage in a good faith process with you as someone who's on a sick leave to figure out, are they able to accommodate you to come back to work with whatever limitations or restrictions you might have. The employer has to do a good faith inquiry on this. Now, you also have to cooperate in good faith with the employer. And so that can also be a failing sometimes. The employer, especially savvy employers, they're able, a very smart employer with good advice is able to basically trip you up by always constantly putting it back on you. Oh, these accommodation requests aren't sufficient enough. We need this further information, and they'll keep throwing it back on you until eventually you give up. And they'll say there's no discrimination because the ball was in their court to give us the new information, and they didn't do it. But most employers, well, I won't say most, a lot of employers will run afoul of the law by not putting enough effort in, a good faith effort to determine if there should be reasonable accommodation. Like one of the most common cases that I handle now are workplace discrimination cases involving disability, just because our firm focuses on employment law and disability law. This is pretty much one of our, most desired cases to handle. We have a lot of experience in this area. So we see all kinds of examples of employees being fired, either coming off a sick leave while they're during a return to work program, before the return to work program, all types of scenarios. We've even seen some where the client really didn't even have a disability, but the employer perceived that they did, or the disability got better. Even that's fine. You don't have to have a permanent disability for there to be disability discrimination. As long as the discrimination happened because of the perceived disability, it's more to the employer's state of mind of what they were thinking about it that can get them into problems with disability discrimination. Now, no job is ever like completely protected. There are types of protected leave. Like leave means when you can take kind of an absence from work. There are protected leaves that are protected under provincial and federal laws. These can be things like sick leave, maternity leave, parental leave, bereavement leave. There's a bunch of leaves that are protected for certain periods of time that an employer is legally unable to fire you if you take that type of protected leave. Now, again, it's a little bit of a complicated area. So outside of that, employers still are able to they're still able to legally fire an employee who is on a sick leave. It's just difficult for them to do so. So while you have job protection, that no job protection is absolute. All that you're ultimately protected on is that if an employer is going to fire you, it can't be for a discriminatory purpose, And also, it can't be for a discriminatory purpose, and they must also pay you whatever severance pay that you're owed based on the circumstances of your case. And the amount of severance pay owed is very unique. It will depend on a bunch of factors, including your individual employment contract, how long you've worked there, personal factors like your age and this type of thing. So ultimately, that is what you're entitled to. If there's a mix. So there's a mix in that they have wrongfully terminated you because it was over a protected ground of discrimination, which would be disability. So that makes it wrongful. And it also can be wrongful in that they haven't offered enough money in terms of the severance pay that you're owed, termination pay. Okay. All right. Let me move on to the next slide here. So some steps to take if you think something is off. Documenting things is very, very important. The first thing we ask people when they contact us and they say, oh, there was this thing and that thing. And I'm like, do you have that in a text or an email or something? Something so we can't get into a situation where it's your word against their word. We need things documented. I had a case recently and the client was like, oh, I think there was an email, but I don't have access to it anymore. And I was like, well, you know what? That's fine. Because if we do get into litigation, we can subpoena all the emails from the company and it would be in there, presumably. But then the client was like, oh, wait a minute. I thought I emailed it, but it was actually a text and I have the text. And I looked, I was like, oh, wow, like this text is perfect. It's like, I'm going on a sick leave. So a lot of times we have to be able to prove that you notified them about your sick leave and they were on notice. And then, 2 weeks later, they fire you. If we can't prove that you notified them, it makes it much difficult to do the case. So in that situation, the client was able to find a text and it was like beautifully worded. I was like, it's almost like a lawyer got you to write this. But it was just the regular, how they wrote it. Like, I'm just letting you know, I've got having this medical condition. I'm seeing the doctor, this other thing. And that was extremely important for the case to have that. So documenting things. So even if maybe there's not an email conversation, but say you have a verbal conversation with the boss or somebody, follow it up with an email to them, ideally from your private email so that you get to keep it. If it's in your company email, then it will not be there. If it's not appropriate for you to use your private email to confirm the conversation, so you would just write back and say, just writing to confirm our conversation today. This is what was discussed, yada, yada, yada. That is something that's very important to do, to get it in writing that this happened. It's important that be created at the time it happens, so it will have credibility within the court system and things like that. Now, if you can't send that from your personal email, what you should do is take like a screenshot of it and save it, is basically what you should do. Or when appropriate, just send the text from your personal phone and save the text, is where often. But if you have a company phone, again, take a screenshot of the text and then save it for your own personal records. Because once you're fired, sometimes they'll swoop in right away and they'll take all your everything. They'll shut down all your email access. They'll take your phone, your devices, everything immediately, and you have no ability to download. That's actually a common thing they will do to prevent your ability from downloading or taking any information away. So you should also communicate clearly with the employer when you're on sick leave. You can also ghost them because people get depressed. They just don't want to deal with things, but that will hurt your case. So you want to be reasonable with the employer, responding to their requests, give them updates, let them know what's happening. You should also, very important, when you're asking for any accommodations, like an accommodation would be, I can come back to work, but I have to start out at half days, or the doctor said I can come back to work, but I can't get back to doing the lifting of the boxes right away. I have to ease into that. Get any requests like that where it's a modification, a slight modification to your job. Get that in writing so that you can prove that you let the employer know about this need for accommodations. Again, we have to show that they didn't make a good faith effort. And you don't want to be in a situation where they can say, well, they never told us that they needed accommodations. And you're like, yes, I did. I told you. And they're like, we have no record of that. And then you can see where that goes. It makes it very difficult to do a case where there's no records to prove anything you're saying. As the person filing a case like this, you have the obligation to prove that something happened. And if there's just no proof, then you fail your obligation and the court will just find that there's no evidence that this happened. So we're going to assume that it didn't. You have to avoid that. Getting legal advice early is quite important in these cases. Don't rely on ChatGPT or just Googling things online. I work with ChatGPT quite a bit. It does make a lot of mistakes. So I would still want to get legal advice. While ChatGPT is very helpful for certain aspects, it will screw things up quite badly in some cases. So I use it quite a bit in my work, but I also have to monitor it very, very carefully. It will make up legal cases. It will misstate the law. It may state the law that applies in one province but doesn't apply in another. It can quote. It will quote passages from disability policies that aren't even yours. Even if you've told it, here's my policy, it can still misquote it and quote other policies. Like, there's all kinds of mistakes it can make. So I would really encourage you to be careful about relying on ChatGPT for advice. Maybe at some point it will get to the situation where it is not going to make any mistakes, but we're not there yet. So I would be very cautious about relying on it for legal advice. I would still contact a lawyer to verify exactly what your rights are in your situation. Okay. Now, the legal options that you have, these would be the most common ones that we work with all the time with clients. So you've got the human rights complaint is often one of the best ways to go because it carries the least risk for you. If you lose, you don't have to owe all these legal costs and pay the legal fees of the employer. So that's often a preferred way to go. With the human rights complaint, you can get damages for violation of your human rights, loss of income because you've been fired, that kind of thing. So it is a preferred way to go. The other way to go would be, the easiest way to go would be to, in some cases, not if there's a human rights. If there's a human rights element, you have to go through the Human Rights Tribunal, the Human Rights Commission. In Ontario, you can also go through the courts or a human rights complaint, but you would only do that in very specific situations. The easy thing that anyone can do if you've been terminated and not paid enough statutory pay, so the amount of pay that's listed under the Employment Standards Act in each province, you can go through the employment standards process in your province. You can file a complaint with the appropriate agency, but they can only award damages. Sometimes it's called the labor board, for example. They'll only award damages up to what you're owed under the Employment Standards Act for your province. That's quite limited. That's usually not the entire amount that you're owed. So just keep that in mind. And especially in cases of discrimination, it is not the right way to go. So just know that. The other way to go is wrongful dismissal lawsuit. As I said, in Ontario, you can include human rights damages within a wrongful dismissal lawsuit. That's not the case in most other provinces. So just keep that in mind. There are pros and cons. Like, often we'll decide on a case, like say we're doing a case in, for example, New Brunswick. New Brunswick, you can't file a lawsuit that includes human rights damages. So we will often decide, are we going to only do a human rights complaint? Are we only going to file a lawsuit for wrongful dismissal? Or are we going to do both? Many cases will do both because there can be strategic advantages to doing both. One of the problems with human rights complaints is you don't have the ability to do discovery of the employer. That is a very powerful discovery is very powerful. This is the part of a lawsuit where you can compel the other side to produce documents. You can subpoena documents. You have the power to do that, enforceable through the courts. And it's quite broad what you can get in discovery. And that is often how we can win the case. Because with employment cases, the employer typically has possession of all the critical documents and you do not. So the power of discovery is quite important. When you do a human rights complaint, you do not, as an individual, have the power to discover or compel documents, subpoena documents from the other side. You don't have that power. The Human Rights Commission has that limited power. And so the investigator from the Human Rights Commission can do that, but it's out of your hands. Like, they can choose or choose not to go as far as you and your lawyer might go. And that is, you give up a lot of control there. So when it's appropriate, I like to do both a lawsuit and the human rights complaint. That way, what will usually happen then is the human rights complaint will be put on hold while the lawsuit proceeds, and you can use the lawsuit the power of discovery through the lawsuit to get documents that also support, that can also shed light on things within the human rights complaint. These are related. They're the same. They relate. These documents would relate to the same employer. So that is important to understand as well. They are really all wrapped up into the same proceeding. So just keep that in mind. That is one thing you can do sometimes, is that you can gain information through discovery, through the lawsuit. They would have to be you couldn't do it, like you couldn't use the lawsuit in an inappropriate way. There would have to be reasonable grounds for you to file both of these actions. Okay. You can't just file a lawsuit to try to get discovery of documents when there's not a real basis for the lawsuit to go forward. Okay. Obviously, the final thing is settlements. Like, many cases will settle. Most cases will settle, quite honestly, just at different phases. Cases can settle, like, when people hire us, we write a letter to the employer indicating that we're representing our client, and we will just write out in the first letter, say we're looking to settle for this amount of money, respond in 3 weeks, or we'll be moving ahead with lawsuits and this kind of stuff. Sometimes employers will respond and they'll reject that offer that we've made and make a counter offer. And then we can go back and forth with the employer. And sometimes you just settle directly with the employer. I've actually done that a fair amount. But there will be times where the employer will not want to engage at all. And the first thing we'll hear from is from their lawyer. Their lawyer may engage in a negotiation, or the lawyer may tell us to buzz off. Just a little inside baseball for you. Like, it's common, the employers and their lawyers know that many people will hire lawyers just for the purposes of sending a demand letter where you're demanding payment and making threats, but that's as far as it would go. And they will try to sniff out those situations and just reject any idea of a negotiation and just basically say you'd have to file a lawsuit. So it's kind of a game of chicken. Employers will try to figure out situations where really you're just playing chicken with them and that you have no intention of filing a lawsuit. And so they will often just refuse to pay anything. But once you file the lawsuit or human rights complaint, then now they will step up because they realize, okay, this wasn't a bluff, that you are actually going to pursue this case, and now they will engage in negotiations. So that is something to keep in mind when you're hiring lawyers to negotiate these types of things. One of the biggest reasons that you can negotiate, like, whenever there's compensation in these cases, there can be a range of what you can get. It's never going to be like, with this case, it's this much. There's always going to be a range of what a court could award or a tribunal could award as damages. And to get near the upper end of that range, you really need the leverage of that the employer understands that this could go forward to court, that there's now going to be legal expenses, that this could go forward to the tribunal. There could be damage to their own reputation if the facts of this come out, because once you file these claims, they become public, and it becomes more knowledge that the employer is dealing with an employee over this situation. So that is often where the negotiation, the power, our leverage in negotiation comes from, that there is the threat of a lawsuit or the lawsuit is now on. That gives the employer reasons to negotiate. Whereas if you don't have that, it's very hard. Okay. Just keep that in mind. We do offer services where, in some cases, like, we have a limit of where we can take a case on a contingency fee basis, for example, to do a lawsuit. If a person's case isn't at a level where we can take that on financially for the situation, we sometimes will offer, like, we could represent you, but it would be for a flat rate, but we wouldn't be able to do the lawsuit. The problem with that is, and we are very clear with people, that with this type of hiring us in this way, we don't have a lot of leverage. So we may be able to negotiate a little bit, but we can only push them so far, because at a certain point, they'll just say, nope, that's it, we're done. And there's no recourse. We can't say, okay, fine, then we'll file a lawsuit. We're not able to do that. So it's often difficult to move the employer a lot in the negotiation unless they really are very far off from where a reasonable settlement would be. But it's hard to get them to that top end, where the high end of the range of what's possible for a settlement. Okay. Looks like we got a comment in here, and we'll jump in for that. So let's go to some comments. Thanks for hanging for that discussion, folks. Hopefully you learned something there. If you have any questions at all about settlements, how it works, how it works with hiring a lawyer for these types of cases, how negotiations work, I'm happy to answer any of these questions. So we got a comment from Tyler, who is a frequent watcher. It says here, someone repeatedly parks in front of my house and drives off every time I come outside. Could this be a private investigator? Yeah, it's possible. Yeah, it's possible it could be a private investigator. Typically, private investigators, they're only going to work for a short period of time. So if this was going on for weeks at a time, I doubt it's a private investigator. Typically, private investigators are hired to go for a few days. They're not hired to go there for like a month. The insurers are not paying that kind of money. So it could be a private investigator if this was over a short period of time and then they're gone. But if it's over a longer extended time, no, I doubt that it is. And again, it may not necessarily be a private investigator. It could be any number of other things. I've had people that swore up and down that there was a private investigator, and the insurance company has denied it. Now, the lawyer for the insurance company denied it, and I would trust the lawyer. I wouldn't trust the insurance company on that. So sometimes there's investigators. Sometimes there's investigators, but they're not hired by the insurance company. Maybe it's involved in a divorce litigation or some other kind of thing. But yeah, it could be, or maybe it's just happenstance that it's a person there for whatever innocent other reason. Maybe they're surveilling the person across the other side of the road. Maybe they're there for some other reason completely. It's hard to say, but it's not unusual that if you come out and you are maybe agitated because you think that this is someone who is a private investigator, that it might scare the person off for whatever reason. But I wouldn't necessarily assume that it's a private investigator, but it certainly could be. All right, I'm going to check my old forum here. Forum. See if there's anything new. Nothing new. Okay. We're so up to speed with this answering questions on here that okay. So let me know if you have any other questions, folks. I'm happy to answer them. Okay. Been a busy day, very busy day. We're doing a lot of revamping of our services and things, so I've spent a lot of time doing that. We're in the process of moving one of our office locations, so I've been dealing with that. And so very busy day. Okay, we got another question here. This one says, could an income source connected to calculating the 85% all maximum fee be regarded as an offset? Yes, it would be. Yeah. So it is an offset. Yeah. Usually, like, these are worded in different ways. I think I mentioned the one I was looking at yesterday. A person had contacted me about potential offsets, and I was looking at I had to finish it this morning and sent them a big email this morning, but actually, I don't know if I sent the email. I got distracted here and I haven't had a break since. So I have to send that email before I close off the day here. So I looked at theirs, and their policy did not have an 85% all sources maximum. It just had all direct offsets. But usually you will see it's leveled out in two parts. There'll be the first part. We'll talk about these are the direct offsets. And then it will say the alternate calculation is this all sources calculation, which is usually at 85%. That's a very common number. And it will list the type of offsets under there. It will include some of the direct offsets and then a more broader category, but those are considered offsets. Now, with the 85%, it is an offset, but it may not, the offset incomes may not add up enough to reach 85%. And if they don't, then you would keep your full disability benefit if that's the calculation that's being used. Very good question. I also had someone just email me a second ago. noting that one of our book downloads, it just it's all automated. So like when you fill out a form to request one of our books, like here, I'll just show you. One of the books, when people were requesting it, all they were getting was a cover. I did not know that. There's been like so many people. This is the first person that has told me, and that's kind of worrying. So now I've got to go and I need to go find all the people that have ordered this book. It's not my main book. It's the roadmap book. That book is designed for self-employed professionals like doctors, lawyers who have to do a disability claim. But I'll just show you what I'm talking about here. So if you go to our books on the homepage here. Where is it? Yeah. So it was this book here. So people ordering this book, filling this out, they were getting sent it says, click here to download your book. And it was just a picture of the cover, which is pretty bad. Pretty bad. Hopefully we'll get that. I'm going to actually, I do have that fixed. So, okay, here we go. Another good question. This one says, what is a reasonable time for an employer to accommodate? In my situation, it's been 3.5 months and I've not heard from the employer. Yeah. Okay. Well, you're perfect for this. You're exactly what I'm saying about them ghosting you and not replying. That can mean many things. It can mean nothing at all. It can just be incompetence. It could also mean that they're not responding because they're trying to figure out what they're going to do. It could mean that they're waiting on other people, like they've taken your request, they've pushed it up the chain, and then someone else, for whatever reason, is procrastinating on it. They could be waiting on legal advice. There's all kinds of reasons that there could be a delay. It doesn't mean that it's a calculated thing. It just can be people being busy at different points and you're waiting on other people. People forget about it. So there could be all that going on. But yes, the reasonableness would be like very much tied to the circumstances. Like, how soon are you hoping to go back? Like 3.5 months is a long time to wait if like you are imminently trying to deal with an accommodation to go back to work. Or if you're still at work, okay, maybe you're still at work and you're asking for an accommodation, then I would say 3.5 months is very unreasonable for them to not respond at all. That would be like 3.5 months is not reasonable to not hear anything about it. No. So I guess it would depend on your situation, whether you're still working, if you're off work, looking to go back. It's all going to depend on that, really. But 3.5 is not reasonable. That might be reasonable if there was like difficult requests, but to not acknowledge what you're sending, that not right. I would continue to follow up and just ask for them to confirm receipt and that they're working on it, that kind of thing. Okay, so this is a good clarification here. So this person's clarifying that they've been off work and the employer advised they are willing to accommodate in May. Oh my, yeah, this is not. Yeah, that's really too long. If that's too long, they need to be moving a little quicker than that. Unless there's some other thing I'm not aware of here. That is too long to be waiting on accommodations. So you could follow up again. Like, I don't know if you have income coming in, if you're still on short-term disability or something, but certainly if you were not getting income, this would be a very dire situation and they would really need to speed things up. Yeah. All right. Shut that down. What else have I had going on today? Not a whole lot. It's just the usual. It's been one of these, my days can kind of get away from me if I'm not careful. Like, it's one of the challenges of doing this kind of work, especially where I own the business too. It makes it very difficult because you only have I'm like everybody else. You only have so many hours in the day and you just have to have a few meetings get set up and then your whole day is toast. Like you need stretches of time in order to do work, like literally. And so what happens is if you have to like emails for me are impossible. Like they really are a problem for me to try to keep up on emails because I could just spend all day doing nothing, replying to people's emails. So luckily for me, most emails I get, I just forward on to other team members to deal with it and get back to the person, because literally I would do nothing all day but respond to emails, because I'll respond to an email and get one back. So it's very difficult. Emails are very tough. That's why if you ever email me and I don't respond directly, don't take offense. I just absolutely cannot do it in most cases, because of the timing of it. I don't have the time in the day to do it. Doing a lot of the work I do takes a lot of time, with writing things, preparing legal arguments, that kind of stuff eats up a lot of time. So you need stretches of time to be able to prepare, like to write these briefs and letters and all these kinds of things. And it's difficult. You can't really do it if you're doing emails all day, is one of the things for sure. Yeah, that's why. So we've been working all week. One of the big things I've been working on is we're revamping a lot of our services and just reorganizing how it works internally in the firm. I think I mentioned yesterday, we're setting up a new pod system an idea that I've gotten from other law firms, organizing the firm into pods. For us, it's like a long-term disability pod, employment, CPP disability. And then there's other services we offer that are short of going to litigation. So like consultations, limited negotiations where there's not going to be a lawsuit, these kinds of things. So those are all organized into different pods. A pod just means that there's a designated lawyer and case manager. We call them a case manager. That's sort of like a paralegal and legal assistant kind of tied up in one. So we are formally establishing these pods. And as the business owner, I'm kind of not running any of them, and I'm more there to support the pods and to deal with overflow and this kind of stuff. So we're doing some shifting around and organizing to make this happen, to get things to work a little more smoothly. It's easier for the lawyers who in our firm who aren't dealing with all the stuff that I have to deal with as the person who runs the business. They can literally, they will have more stretches of time where they're not constantly on the phone. Or now they still do get a fair amount of emails, but not to the extent that I would, because I'm getting them from all angles, like from clients, from vendors, from the person I'm negotiating the new rent with, the new office space, and all that kind of stuff. So it is a challenge, very big challenge. A lot of people, like when they hire, they want me to be their lawyer, but technically now we've made it so that no longer pretty much is the case. I'm no longer the lead lawyer on most cases, just because it's not efficient. And I will be involved in a lot of the cases, but I won't necessarily be the main lawyer that you deal with. And that's just by necessity at this point. I get overloaded with work, and then it's hard to get stuff done. And then things, this is one of the problems you run into with lawyers. It's very important with law to have it as a very streamlined team of people that have dedicated roles to make sure these things move quickly. Otherwise, you get into situations where these cases can drag out just because of inefficiency and difficulty with the human resources of moving these cases along. So just keep that in mind if you're ever working with lawyers. Okay. All right. I guess that's it for today. Glad you guys all showed up. We'll be done for the week. We'll be back again next Monday. And just come with your questions. We'll have a new slate of topics and things to talk about. I wish you guys all the best. Have a good weekend.